Today's video is rules and theory for OCR A Level Law, where we will go through an outline of criminal law and an overview of the theories of criminal law. Now for OCR, this will be in section B of paper 1. We will now quickly go over the OCR A Level Law specification for this topic. We'll need to be able to define a crime, key characteristics of a crime, sources of criminal law, elements of criminal liability, the participants in a criminal case, burden of proof, standard of proof and reverse onus, aims and purpose of criminal law, and the principles of criminal law. So just from me, I want to give you a quick tip. So there'll be no essay structure for this subtopic, but it is used as a base for essay writing. So you can kind of show the examiner that you know what you're talking about and it makes sense when you're writing it and reading. Now, this subtopic is a base for understanding future subtopics and topics. So it kind of links to basically everything and loads of cases, so it's very important. First, we'll be going through definition of a crime. It is an act or omission that is punishable by the state. It is considered a public wrong, meaning it can harm individuals and society. Now, the reason it exists is to maintain public order, deter wrongful behaviour, protect individuals and society, and to also ensure justice. So all summarised, it's basically an offence that violates a legal duty owed towards the state or the public. We'll now be looking at key characteristics of a crime. So behaviour that is deemed harmful to society, prosecuted by the state, and may result in punishment like imprisonment, fines and community service. We'll now be looking at where laws come from, so sources of criminal law. First, we have statute law. Now, this is legislation passed by the Parliament. Now, this is where most criminal offences come from. For example, Theft Act 1958 and Offence Against Person Act 1961. Next is common law, which is legal principles developed by judges through, decisions in court cases. For example, murder and general defences, for example, duress or necessity. Next, we'll be looking at elements of criminal liability. So who is liable? So to establish this, prosecution need to usually prove two components called the actus reus and mens rea. So what do these mean? Like, what are they? Now, it is in a different language, but long story short, actus reus is the guilty act. This is the physical element of the crime or act. Now, this can be an act, for example, punching someone, an omission, for example, failure to complete a duty, for example, when a police officer fails to complete their duty, and a state of affairs, for example, possession of illegal drugs, such as cannabis in the UK. Now, an important case for this is R.V. Miller 1983, where the defendant started a fire but didn't take any steps to stop it. So there was an omission and found guilty. So next we're going to be looking at mens rea, and this is the guilty mind. So this is the mental element of the crime, and it reflects the intention, knowledge and recklessness or negligence of the act. Different offences require different levels of mens rea. Now, there are some crimes that do not require mens rea, which are strict liability offences. For example, selling alcohol to minors. So, who are the participants in a criminal case? Let's have a look. So, first we have the prosecution. Now, they represent the state and they have the responsibility to initiate the proceedings. Their role is to ensure that justice is served fairly. Secondly, we have the defense. This represents the accused, aka the defendants. Now, they challenge the prosecution's evidence, present legal arguments. They can also raise defenses that go against prosecution, for example, self-defense, and ensure defendants' rights, for example, the legal representation. Next, we have burden of proof, standard of proof, and reverse onus. So, burden of proof depends on prosecution, and basically, they must prove all the elements of the crime. There's two types, which is legal burden and evidential burden. Legal burden is, for example, to prove legal facts, and evidential to prove evidence. Next, we have standard of proof. This is the level of certainty that the defendant is guilty. And if there is any reasonable doubt, then the case may be acquitted. Now, the reverse onus is when the burden of proof shifts to the defendants. For example, if they plead a defense like insanity, this must be proved by them. Next, we'll be looking at aim and purpose of criminal law. Firstly, we have protection, so simply protects individuals, protects property and public. Next is maintenance of public order, maintains peace and protects, supports the authority of legal institutions. Next is punishment and retribution, so wrongdoers should be punished basically. Next is deterrence, to reduce offenders reoffending, and general public committing offences. Also rehabilitation in order to reform offenders, in order so they can kind of reintegrate into the society as individuals. Next, we have lastly, we have principles of criminal law. These are foundational values guiding criminal law, including legality, the belief that only guilty offenders are to be punished. We also have fair labelling, so offences should be labelled based on nature of seriousness. Moral culpability, so whoever is morally at fault should be punished. Proportionality, so that punishment is equal to the harm that has been caused. And presumption of innocence, this bit got cut out, so I will be rewriting it in a few seconds. So presumption of innocence, essentially the belief that a person is not guilty until proven guilty, so proof has to be beyond reasonable doubt. So that's it for today's video. Thank you for watching. Please like and subscribe. It would really help as this is a new channel. And P.S. we are coming out with resources.